to Mark and Julia for inviting me, and to Comhlámh for having this event. And I think the report is really important in itself, in what it does and how accessible it is. It's also, I think, a very important timing at the moment in and around this issue after Justin Trudeau's visit last week, ahead of the crucial period, hopefully, of more public and parliamentary debate around this issue across, not just Ireland, but across Europe, ahead of the decisions whether to ratify the CETA treaty or not, because I think because of the way the negotiations have been done in such a untransparent way, going back to the start in 2009, we haven't really had a chance to fully immerse ourselves in the issues and the seriousness of it as a society, as a parliamentary process, and so on. So I think it's a really important period ahead of us now. Okay, so to try and just cover a little bit of the issues around the legal questions. You've probably all heard in some shape or form about this ISDS or ICS, the various acronyms. So the Investor Court System, as it's called now, which is essentially a type of investor versus state dispute settlement mechanism, right? So this is the model that international investment law has developed over the last number of decades for resolving disputes under investment treaties between corporations on the one side and host states on the other. And this is just to, I suppose, emphasize, this is very much in contrast to the model that we're used to dealing with in international trade law, so the laws relating to trade between states under the World Trade Organization system, which is a state versus state dispute settlement system, right? So if there's a dispute, it's two governments, two states that are negotiating at first, and if that doesn't work, then adjudicating or arbitrating disputes between them in a court-like process, right? But it's the two states, they're accountable to their public bodies and their populations, right? So the investment law model is very much designed to facilitate the protection of foreign investors. And so the model there is that if there's a dispute, the corporation who's investing in a host country can sue the host state, but not the other way around. And the reasons or the basis for them taking a claim like that can be based on really what they would see as policies or laws enacted by a host state that would unfairly harm their commercial interests or expropriate directly or indirectly their property, their assets, or their profits, including future profits, right? And so we've a lot of problematic language in there around what's called legitimate expectation for essentially future profit. So if you invest in a country, you claim you have a legitimate expectation of future profits from your investment, and a policy or a law is brought in the public interest to change that, you can in many cases successfully bring a legal claim against the state and receive large payouts. And this has happened time and time again over the last number of decades, and particularly in the last 10 years. And so when Mark says, this idea that public representatives say, well, this isn't true, it couldn't be true, how could we possibly let foreign corporations have these entitlements over us and leave ourselves exposed to that risk? People that are saying this aren't looking at the empirical evidence and the history and of these types of cases, right? So there's loads and loads of examples of these types of decisions. I'll give a couple of examples, but we could go on listing them all night. But I suppose just to say that why is this system in place, and how has it become the model for this agreement? This goes back. It's essentially going back to the early days of investment from global north corporations into the global south in the aftermath of the decolonisation period. And this model was brought in essentially to protect Western companies who felt that they couldn't trust the legal systems in Latin America or Africa or Asia where they wanted to invest, but they didn't trust the courts or the judiciary there. So this external commercial court model was set up essentially in their interest, right? So it's very much a neo-colonial kind of story, but it's now becoming universalized through these new generation trade deals, right? And the decisions, the types of things, and that's why, to a certain extent, because of all these payouts that have been ordered against states at the receiving end of this, the likes of Brazil and South Africa and other countries are now disentangling themselves and trying to disengage from this system because they've seen how coercive and unfair it's been. Right, so, and some of the decisions really have been shocking, right? So 2012, there was a investment tribunal ordered the government of Ecuador to pay out $2.3 billion in damages to Occidental Petroleum Corporation over a democratic environmental policy decision that was taken in Ecuador, but was seen as affecting the interests and the commercial rights and profitability of Occidental Petroleum, right? So 2.3 billion in that case, and we have those kind of really shocking examples, particularly in the environmental sphere, down to more mundane type of examples where, for example, in and around the same time, a few years ago, Slovakia was ordered to pay out damages to a Dutch health insurance company after a democratic decision in Slovakia to switch its health insurance system from a private insurance system to a non-profit system that was seen as indirect expropriation of the profits, the future profits of the Dutch company. They brought this case and won in an investment court, got a payout of more than 20 million euro. The Slovakian government refused to pay it, and so the Netherlands government was then able to get an asset seizure on Slovakian government assets in Luxembourg. And so these are the types of things that happen, and we have overall a success rate for the corporations taking these cases of in the region of 50 to 60%. For the biggest corporations, over 70%, right? So the bigger multinationals with the biggest budget for lawyers and so on are winning more than 70% of these cases that they're taking, and of the total payouts over time, some of the empirical work that's been done on this, of all of the successful claims that have been brought by corporations, 73.3% of those have been brought by what are defined as extra large or super large companies, right? So companies with more than $10 billion in annual revenue, they've received 73.3% of the payouts, whereas small and medium enterprise businesses between them, less than 100 million annual revenue for small business, between 100 million and 1 billion annual revenue for medium, so still big enough companies, they've between them received 1.3% of the payout. So we can see in those figures where the interests lie in this system, right? And so the question is then why is this so fundamental to the CETA agreement and TTIP and similar agreements? The German economics minister a couple of years ago wrote an open letter to the EU Trade Commissioner about the time and raised some issues around this and suggested that this type of system was unnecessary between countries with well-developed legal systems like Europe and Canada, right? So why do we, why is this aspect so essential to the Canadian government and the European Commission to this deal? There's been a lot of opposition to this in the public response to TTIP and CETA. They've been aware of this and have acknowledged this partially through kind of repackaging it from an investment arbitration system to an investor court system, and they've tinkered with the cosmetics of it, but the essence of it is still the same. And there haven't been, I don't think, any coherent answers as to why this was, if this is a problem and acknowledged, why not just leave it out of the deal? Why is it so essential to keep it in there in spite of all of the opposition? In whose interest is it being included, and what does that tell us about the trust of the agreement as a whole? And so I would urge everyone to think about that, to ask those questions. Some of the questions that are in the booklet for your TDs and senators are very useful in trying to get at some of this and trying to unpack, I think, what the purpose of this deal is, because the representatives and the official response will be it's about lowering tariffs, increasing flows of business between the two blocs. But we know that international trade law has been doing this since 1947 for 40 or 50 years. It was solely and only focused on reducing tariffs, so that the tariffs now are almost non-existent between Europe and the US, or between Europe and Canada. At the start of the GATT system in the 1940s, the average transatlantic tariff was about 40%. Now it's about 4% on average. It will vary depending on the sector and the type of goods, but on average 4%, and so we're really, talking very low end of the scale. And so what this deal really is about is the non-tariff barriers, right, which is a kind of a euphemism for talking about things like environmental protections, health and safety standards, workers' rights, food quality requirements, and so on. And we have this other aspect of it, which I'll finish with maybe, which is about regulatory harmonisation or regulatory cooperation, right? So this is the other second main pillar that the booklet mentions in the introduction, along with the legal court system. And this is, under the treaty, basically there's various forums created for imposing new obligations on European and Canadian regulators to work towards regulatory convergences to make the regulation systems the same in both sectors, and that will inevitably, and again the experience from previous trade deals that have included these type of measures shows us that doesn't involve a hiring of standards to the best level of standards. It involves a reduction to the lowest common denominator in many instances, right? And so there's serious questions there for a whole range of sectors. There's a lot more we could say about that, but I'm conscious of the time, so I'll maybe leave it there. If there's some interesting examples. There was a report out just this month about EU and Canada regulation of pesticides and the differences there, and the inevitable lowering of standards in pesticide regulation as one likely impact of the CETA deal. And just, I suppose, the other point to mention in general terms, and particularly in relation to the investor court system, is Ireland's particular exposure because of the high levels of foreign investment that we have, and particularly in areas like pharmaceuticals and tech, where the companies in those sectors have shown themselves to be very litigious and very willing to throw a lot of money at challenging laws and policies that affect public health or affect data privacy and so on. And even the EU Trade Commissioner has acknowledged this, that Ireland is kind of in a way uniquely exposed to this, and we're one of the few EU countries that's not already tied up in this investors versus state dispute settlement from other treaties. We're outside of it altogether, and it hasn't affected our levels of investment. So again, why do we need it in this instance? Okay, I'll stop there.
Thanks, John. Again, if you have questions, if you could hold them, and we will take them together then at the end. Okay, our last panelist tonight is Senator Alice Mary Higgins, who possibly needs no introduction. Alice Mary is the Senator of the NUI panel, elected at the last election, and Alice Mary has taken a leadership role in the Seanad on the question of CETA, sponsoring a motion on the ratification, and interestingly, it's passed. So what we hoped Alice Mary might do was kind of give her own perspectives on some of the key issues, but also then looking forward, because this is now a moment for action. This is now the moment to move. This is a window of time, and it'll close. And so, Alice Mary.